deliver reasons which span over 322 pages and 1,203 paragraphs, instead of just simply identifying the orders I propose to make. What I intend to do is read briefly from the introduction to the reasons and also the conclusions. Mr. Kelvin McNichol lived what might be thought by a young lad to be an Australian idyll. Born in September 1982, he grew up on a rural property on the beautiful mid-north coast of New South Wales. His father operated a vegetation management business, and during school holidays, Mr. McNichol assisted his dad clearing vegetation. But this was no passing stage. After completing school, Mr. McNichol began working full-time for his father. No doubt it was hard work. Almost every working day, Mr. McNichol and his father sprayed a weed killer called Roundup on weeds and other unwanted growth using a knapsack sprayer or a drenching unit. As might be expected, drips or leaks of the Roundup soaked through his clothes and onto his skin. Mist or spray would go all over the place and get into his eyes and onto his face, and fumes were inhaled. Some years later, after marrying, Mr. and Mrs. McNichol left Coffs Harbour for Darwin. Mr. McNichol is an apparently devout man. The Apostle Paul said, "Let him do hard work, doing with his hands what is good work." Apparently motivated by the perceived moral value of good and hard manual work, Mr. McNichol volunteered to maintain the lawns and gardens at the Kingdom Hall of Jehovah's Witnesses. His evidence is that in doing so, he used Roundup. In May 2018, Mr. McNichol was diagnosed with a form of cancer known as non-Hodgkin lymphoma. Just over a year later, he was informed by a haematologist that he was in ongoing remission. Unfortunately, about 6 weeks prior to the commencement of the initial trial, his NHL recurred. As a result, Mr. McNichol was unable to attend the hearing. I have introduced Mr. McNichol, who is the lead applicant in this class action, but this judgment is not, at least directly, about him. This is not the occasion to deal with questions of individual causation. Rather, when this initial trial was fixed, it was contemplated that I would determine a set of common questions relating to Mr. McNichol's contention that during a period from July 1976 until an end date defined at the time I made the orders, glyphosate, glyphosate-based formulations, and Roundup herbicide and Roundup bioactive, which have glyphosate as a component, were carcinogenic to humans. The respondents, Monsanto, reject this contention completely. The common questions were identified in orders made by consent following a case management hearing in April 2023. As it happened, issues were refined during the initial trial. In the end, for reasons that are become apparent in the reasons, the determinative question is whether Mr. McNichol has discharged his legal onus of proving on the evidence adduced that the use of and/or exposure to Roundup products can increase an individual risks of developing NHL or cause an individual to develop NHL. I call that, in the judgment, unimaginatively, the central issue. I divide the reasons into a number of sections. I deal at length with the proper approach to fact-finding and the legal method, the factual background, the structure and consideration of the scientific evidence, the first of 3 streams of scientific evidence, the first being epidemiology, which dealt with conclaves C, D and E, the second stream of animal studies, which deal with conclaves H, I and J, and the third stream dealing with mechanistic evidence being conclaves A, B and G. I then separately deal with conclave F, which dealt with absorption, exposure and dose. And then in section I of the judgment, I draw the threads together. And I'll read from that section. We now come to, this is at paragraph 1133. We now come to the step required to be undertaken by a court and which reflects the imperative that a judge, unlike a scientist, must decide one way or another whether the burden of proof is satisfied by the party positing a general causation hypothesis based on scientific evidence. As Mr McNichol correctly submits, it would be an error of reasoning to reach the conclusion that just because each of the three streams of scientific evidence do not establish general causation, that this axiomatically provides an answer to the general causation issue. As I explain in depth in the reasons, I'm required to direct myself by having regard to all the streams of scientific evidence and any other material admitted in ascertaining whether Mr McNichol's onus has been discharged. As I recently noted in Lerman and Network 10 Proprietary Limited 2024 FCA 369 at 98, assessing whether this burden has been discharged does not involve a simple estimate of probabilities. It requires ascertaining a subjective belief in a state of facts on the part of the tribunal of fact. Mr McNichol, being the party bearing the onus, will not succeed unless the whole of the evidence establishes a reasonable satisfaction on the preponderance of probabilities such as sustain the relevant general causation issue. Put another way, I'm required to assess whether I have formed a subjective belief or actual persuasion of the existence of the necessary causal connection. As Justice Hodgson put it, I'm dealing with two questions. Not just what are the probabilities on the limited material which the court has, but also whether that limited material is an appropriate basis on which to reach a reasonable decision. Bearing these matters in mind, the whole of the evidence in the three streams reveals some not insignificant issues with the evidence presented by Mr McNichol in favour of his contention that the use of and/or exposure to glyphosate and/or GBFs can increase an individual's risk of developing NHL or cause an individual to develop an NHL. Indeed, much of the evidence was directed towards establishing plausible or theoretical possibilities. But it is not enough to persuade the court that glyphosate and/or GBFs might cause or increase the risk of NHL. Actual persuasion necessitates more. Namely, the court can be reasonably satisfied that glyphosate and/or GBFs are capable of causing NHL in humans. It's partly for this reason that the epidemiological stream causes difficulty in accepting Mr McNichol's case. Without placing disproportionate focus upon it, it is, after all, the stream of evidence before the court that examines the actual occurrence of cancer in humans exposed to glyphosate and/or GBFs in the real world. This was recognised as long ago as February 2022 when Mr Clements KC accepted that one of the critical areas of expertise in which expert opinion evidence will be adduced in this case is in the field of epidemiology. In saying this, however, I am conscious that epidemiology may not establish a positive link between glyphosate and/or GBFs and NHL, but this does not entail that such a link does not exist, although it would have to be established by other evidence. In other words, epidemiology which establishes a positive link between agent and effect is neither a necessary nor sufficient condition for establishing causation. But in the end, the evidence adduced in the first stream established, in order of importance, that 1, the agricultural health study represents the most comprehensive and reliable analysis to date of whether there's a causal relationship between glyphosate and/or GBFs and NHL because, inter alia A, in the light of the sheer number of study participants involved, the AHS is of a different character than any comparable study on the relationship between glyphosate and NHL, and B, in contrast to a population-based and community studies, the sample in the AHS consists of applicators who are occupationally exposed to GBFs and other agents thought to be carcinogenic. 2, the vast majority of the case control papers, A, involved a relatively small number of cases and controls who were exposed to glyphosate, and B, suffered from the failure to correct for exposure to other pesticides, that is, confounding. It is for these reasons that the epidemiological literature does not support the conclusion that exposure to glyphosate and/or GBFs is capable of causing NHL in humans. It is well to emphasise here that the AHS was not only described by Professor Checkaway as excellent and perhaps the best study we have, but it is plain in the light of its size and nature of exposure to the study participants experienced. If glyphosate and GBFs were causative of NHL, one is faced with the reality the relevant association was not observed. As for the animal study stream, the evidence was insufficient to establish that 1, glyphosate causes cancer in murine subjects, And 2, even if it does, the causation of cancer in rats and mice entails that it also caused cancers in NHL in humans with real-world exposures. It will recall that 1, Dr. Bayard's evidence was marred by approach that A, did not meaningfully assist in eliminating positive rates because it did not involve any adjustments to the p-value which accounted for the problem of multiple comparisons. B, included pooled analyses in circumstances where there were a variety of substantive differences in the animal bioassays, such as different durations and dose levels. And C, involved Dr. Bayard giving scientific opinions on fields outside of expertise. 2, the animal bioassays and Wang 2019 suffered from several limitations, including, among other things, A, in relation to each tumour type in rats and mice, and perhaps most importantly, the majority of the studies did not indicate a statistically significant result according to Dr. Bayard's predetermined criteria for significance. B, a number of the animal bioassays reported inconsistent results when assessing relative dose levels. C, a number of the tumours identified by Dr. Bayard are not rare in rats and mice. And D, several of the animal bioassays lack cross-gender significance. And 3, Dr. Bayard's reliance on Wang in the context of the GRI was not of assistance in demonstrating the transability of the animal study's evidence to humans because A, Dr. Bayard lacked the requisite qualifications to conclude that the study provided evidence that glyphosate provides a mode or mechanism of action by which it can cause cancer, and B, the extrapolation of findings the subject of such model to humans is a question which necessitates high translatability and the application of a number of criteria, including inter alia, the animal species, dose exposure, and the similarities in biological response. Lastly, in relation to the mechanistic evidence stream, although the evidence established that glyphosate and GBFs exhibit GC2, GC4 and GC5, the evidence does not support the next step that there exists a corresponding biologically plausible mechanism by which glyphosate and or GBFs can cause NHL. This is particularly evident in relation to GC2. Further, it was apparent that Mr. McNichol's reliance on the second hypothesised mechanism and Wang was misplaced in the light of a slew of limitations which rendered it of limited assistance in demonstrating whether an unregulated regulation of AID contributes to the development of NHL in humans. Even in the event that the mechanistic evidence allowed a more definitive conclusion to be drawn as to an association between glyphosate and or GBFs and the development of cancer, it is well to emphasise that there is inadequate evidence of cancer in humans and insufficient evidence in experimental animals. The mechanistic evidence in cases can only suggest that the substance in question is possibly carcinogenic to humans. I'm acutely conscious that in his opening, Mr. Clements submitted that the approach of Monsanto is that all the studies have flaws. There's the same old approach. Ignore the smoke, there's no fire here. They do the same thing with all the other studies. Monsanto's drumbeat as the results of the AHS in its submissions was potentially deafening. But consistently with Mr. Nicholls' submissions, I've guarded against being distracted from the full sweep of the evidence by mistakenly elevating the epidemiology evidence, and in particular the AHS, as some form of necessary condition for establishing causation. More generally, I've sought to ensure that I have not been diverted from weighing the whole of the evidence by focusing too intently on complaints about individual studies, which have ranged from the highly significant to the pettifogging. Mr. Clements correctly urged me to view the evidence in the round, and I've attempted to do so. Stepping back and viewing the evidence of a whole and faithfully giving weight to those aspects I consider most cogent, but without giving disproportionate emphasis to any particular stream, the state of the evidence is not such as to sustain the necessary causal connection. This is not to say the evidence suggestive of a causal link did not give me some pause, and I will say something shortly about the appropriate answer to the question posed at the initial trial and as to the ongoing scientific controversy more generally. But the weight of the evidence adduced in the three streams made it difficult to come to any conclusion other than the applicant has not established his general factual causation case to the requisite legal standard. I then deal with the Merck orders and then turn to the form of the questions. The central issue, which in the end has turned out to be determinative, can be seen reflected in the terms of a question known as question 4. This is not an unexpected development, and it informed my desire to have an initial trial on the question of general factual causation. At the close of evidence, I invited submissions as to whether I should necessarily answer a question other than a refined question of question 4. I accept that may have been utility in answering all questions in the event that Mr McNichol had generally succeeded. But as Monsanto correctly submits, this initial trial is about the central issue, and as Mr McNichol accepts, if the course answers no to all parts of question 4, it would follow this proceeding would be dismissed. The problem with question 4 is that it is unnecessarily complicated and does not reflect the pleading. This is a case concerning Mr McNichol and other persons who have been exposed during an identified period to Roundup products within Australia. Roundup products are defined in the pleading as a herbicide product or products which contain glyphosate and were branded as Roundup, or which contain glyphosate or otherwise branded with the name Monsanto. No one during the trial has sought to draw any relevant distinction whatsoever between the two Roundup products used by Mr McNichol and any other Roundup product, or more generally, and subject to a qualification irrelevant for present purposes, any material distinction between Roundup product and any other GBF. The use of Roundup products is a common thread linking all group members. While the case was run without distinction between the carcinogenic properties of Roundup products and other GBFs, the question posed and answered by the court should be grounded in the common facts between group members and not strained to some hypothetical statement about any other GBFs, even if the answer would be the same on the evidence in this case. Despite written submissions contemplating some possible mixed response to question 4 by Mr McNichol, this position was subsequently modified, and each party accepts question 4 can be more simply expressed and reflect the central issue by being expressed as follows. Throughout the period between July 1976 and 19 October 2020, relevant period, a period I'll explain momentarily, did or could the use and of exposure to the herbicide product or products which contain glyphosate and which were branded Roundup, or which contain glyphosate and were otherwise branded by the name Monsanto, Roundup products, increase an individual risks of developing non-Hodgkin lymphoma and or cause an individual to develop NHL. Obviously enough, an answer which amounts to a declaration should be clear on its terms, and hence the question and answer should be self-contained and not adopt defined terms. The appropriate answer. The difficulty is that my resolution of the central issue is not captured by a simplistic binary response to the central common question. The answer to a separate question, such as the central common question, operates as a form of declaration of legal rights. I explain, this reflects the legal approach to a proof of a fact, and just because a moving party fails to persuade a court to make a declaration in the terms it seeks, does not mean the opposing party is entitled to a declaration in opposite terms. If, as Monsanto asserts, I simply answer no, this would amount to a distortion of my resolution of the central issue according to law. This is because to say Mr McNichol has not proved to my reasonable satisfaction on the balance of probabilities on the state of the evidence adduced at this trial that the use of and exposure to Roundup product increases an individual's risk of developing NHL or causes an individual to develop NHL is not the same thing as saying affirmatively that it does not. As I've explained, whatever else is unclear, one thing is plain: the science is not all one way. Even leaving aside evidence adduced on behalf of Mr McNichol, Professor Prince accepted that there was some evidence that exposure to GBFs cause or contribute to the development of NHL. Further, he accepted there's aspects of what GBFs can do which are known to be causative of lymphoma. Associate Professor Harris accepted it is quite possible that glyphosate use may be associated with increase of NHL, and Dr. Dewberg gave evidence that based on my review of the available and accessible material, I conclude that none of these studies support a clear and compelling basis for carcinogenity of glyphosate in mammals. At the forensic level in litigation, truth is static, but the scientific method involves the positing of testable hypotheses based upon empirical observation, and any theory formed by its nature is generally contestable. It suggests hubris and defies common sense to assume further scientific research and analysis could not mean more definitive conclusions may be able to be drawn using the scientific method, including buttressing the notion that Roundup products are possible carcinogens. One cannot foreclose the possibility that further research may reveal a compelling link, a fortiori a sufficiently persuasive link on the balance of probabilities demonstrating that the use or exposure to glyphosate and GBS causes lymphoma. As I am at pains to emphasise in the reasons, I'm deciding as to my reasonable satisfaction on the balance of probabilities based on the evidence selected by these parties and which can only represent a snapshot of the state of scientific knowledge at the time the evidence closed. Although any Section 33ZB order would not operate in rem and would only relevantly bind Mr McNichol and group members specified in the order to the answer of the central common question, it's important that the orders of the court do not distort the result of the forensic contents in this trial. I then deal with an issue of group members and conclude that any Section 33ZB order should be made binding the current group membership as defined in the second further amended statement of claim filed on 9 October 2020, other than those that use the opportunity thereafter given to them to opt out. Finally, I deal with costs. It continues to be said that the court's discretion in awarding costs is unfettered, but that is best overly simplistic and at worst inaccurate. Any power to award costs must be exercised in a way that promotes the overarching purpose. Apart from the obvious and weighty consideration that Monsanto has prevailed in the initial trial, there are three factors that bear upon the discretion to making an award of costs. One, the party's conduct and the overarching purpose. I set out in some detail the history of this litigation and my attempts over a number of court appearances in order to ensure that these proceedings were resolved in accordance with the dictates of Part 5B of the Federal Court of Australia Act, which does not, as I indicate, contain empty rhetoric. This means that in conducting litigation and identifying issues, including separate issues which may be determinative, the parties, including a respondent, must be engaged in trying to ascertain ways to simplify and expedite the resolution of matters. The obligation at the initial stages of a proceeding is to give real thought as to how a case might be most efficiently resolved is particularly important in large class actions which demand and consume so many public resources. Any notion practitioners can just roll the arm over and conduct litigation and incur costs like they are in a time warp which has transported them back to a time when provisions as Part 5B did not exist, cannot persist. My preliminary view, subject to hearing further on this issue from the parties, is that despite the efficient and skilled way the initial trial was eventually conducted, it is open to conclude that both parties share a responsibility for this case not proceeding to trial much earlier and with vastly less cost. Secondly, I deal with the nature of this litigation as public interest litigation. And thirdly, I refer to the position of Mr McNichol. As I noted in the introduction, Mr McNichol is a man of modest means, is presently unwell and has a wife to support. However strongly I empathise with the position Mr McNichol finds himself in, I'm aware in ordinary inter partes litigation that any discretion exercised in such a way so as to deprive a successful party of their costs must be exercised judicially and according to rules of reason and justice, not according to private opinion or even benevolence or sympathy. But this is not ordinary litigation. He has relied on others to bring the claim, and despite being unwell, he has performed a signal service in acting as a representative applicant. Mr McNichol will no doubt be disappointed in the result, but his labours have not been in vain. His individual case has provided a means by which the evidence currently marshalled has been evaluated and assessed, thus resolving the legal rights of a great many people. At the end of the day, any ordinary cost rules are to be subject to the ability of the court to make further or other orders as required to achieve a just result. In the last respect, I'm conscious that Monsanto has made submissions as to why the court, open quote, should not be concerned as to the ramifications, close quotes, of making costs orders against Mr McNichol. But so far as I can see, those submissions go beyond any evidence that was adduced at the hearing. and subject to any without prejudice material relevant to costs that may be admissible because of section 1312H of the Evidence Act, the parties agreed that the open quotes entire universe of material close quotes to which I have regard in making any final orders has already been adduced and is in evidence. If a costs order against Mr. Meikle is to be pursued, I will allow for further evidence as to costs subject to any application, restricted to material admissible because of the exception contained in section 1312H of the Evidence Act and submissions made as to relevant considerations. For the reasons set out in the judgment I will shortly publish, I make the following orders and make the notations set out below. 1. Pursuant to section 33ZF of the Federal Court of Australia Act 1976 Commonwealth, and notwithstanding that no application has been made by the representative party in accordance with section 33K1 of the Federal Court of Australia Act, leave be granted for the group membership to be amended nunc pro tunc so that it is defined as it is in the last version of the statement of claim filed prior to the fixing of the date for opt-out, being the second further amended statement of claim filed on 19 October 2020. 2. Pursuant to section 33ZF and section 37P2 of the Federal Court of Australia Act, the following question, common to the claim of the applicant and all group members, central common question, be answered separately and before any other question or issue in the proceeding. Throughout the period between July 1976 and 19 October 2020, relevant period, did or could the use of and exposure to the herbicide product or products which contain glyphosate and were branded as Roundup, or which contain glyphosate and were otherwise branded with the name Monsanto Roundup products, increase an individual's risk of developing non-Hodgkin lymphoma, NHL, and or cause an individual to develop NHL. 3. The central common question be answered as follows. It is not proven in this proceeding on the balance of probabilities in accordance with section 141 of the Evidence Act 1995 Commonwealth that throughout the relevant period use of and exposure to Roundup products increase an individual risk of developing NHL and or cause an individual to develop NHL. 4. The proceeding be dismissed upon finalisation of any issues relating to costs. 5. Any further evidence as to costs is contemplated in the reasons at 1202 and any submissions as to costs be filed by 12 noon on 30 June 2024. 6. For the purposes of section 33ZB, the Federal Court of Australia Act, orders 1 and 3 above effect and hence bind all current group members in the class action, being those named in the second further amended statement of claim who did not opt out. 7. The proceeding be adjourned for the parties be heard on the appropriate costs orders in conformity with these reasons at 10:15 a.m. on 31 July 2024. And the court notes that 8, the leave granted after the date of opt-out had passed to amend the statement of claim so as to file the third and fourth statement of claim did not include leave being granted on an application made by the representative party to alter the description of the group pursuant to section 33K1 of the Federal Court of Australia Act. I make those orders. I publish my reasons. The court will now adjourn.
All stand. This court is now adjourned.